Yeah, Henshaw here again, Constitutional Kook headquarters, and more on current events, especially with the COVID moratorium on evictions about to expire, at least in a lot of jurisdictions. And, that's been handy to have, and it damn well should be there because it's this de facto national socialist government that's created this problem to start with. But the really good news here, notwithstanding the availability of any moratoriums or this, that, and the other, is that you get my document packets, modestly priced constitutional defense document packets. Send me an email, youwinnincourt@gmail.com, and you get a lot of bonus information coming your way also initially. But we can prove, among other things, even in their corrupt courts, if need be, that there is no landlord-tenant relationship, most particularly with corporate landlords who, as the record will establish, and it's a stunner, but it's all of it's true, they don't exist. If they're registered at all, we can prove that it's with the Territorial Secretary of State, but we are domiciled in a state judicial district. Those are foreign jurisdictions. They can't come into ours, and they can't compel us into theirs. Simple. And instinctively, a lot of people, you're going to get that right off the top of your head. But studying my materials, you're going to see with attitude and with authority what's really going on here. And with the lame, dumbass, non-existent 14th War Amendment, that's what all these corporations rely on for their citizenship. But guess what? It doesn't exist. Not only that, it has never existed. The 9-0 farts, aka the U.S. Supreme Court, ruled it unconstitutional in 1867. Cases Ex parte McArdle 7 Wall 506, but they were not allowed to announce that opinion to the public. That's an egregious error on the part of the framers. I'm sure they never visualized it as such, 80 years earlier. But, Congress was given control over the appellate jurisdiction of the court. Wow, it's inconceivable now, but probably back then you just simply couldn't imagine an egregiously evil situation like what we had with the war between the states. And it had little to do with slavery, by the way, very little to do with it. We'll talk about that in another video. But that said, we can prove the agreement doesn't exist. We can prove we were fraudulently induced into it, and a lot more besides. And all of it's juicy and delectable. And instinctively, it's the way the system should be operating, given the fact that we've been using now undefined dollars since 1933, at least, HJR 192. So now, and by the way, there are that say there are remedies available in bankruptcy courts. I'm not sure about that. I'm not ruling that out at this time. And bankruptcy, if you don't know, that is an Article 3 court. And if the Congress is required to create Article 3 judicial courts, and you'll learn with studying my materials, that question seems to be up in the air, although it shouldn't be, then the bankruptcy court might be. But if I were to go to a bankruptcy court, I'd be going there announcing the bankruptcy of the United States, not me. Or more accurately, the trust known as the United States. It was created in 1871. They're bankrupt, not us. See you later. That's how that works. So this is a powerful position to take, and it seems unfair in some respects on the surface, because landlords, you would think would have some rights, but not if they're corporate landlords and they owe their citizenship to a non-existent amendment. They don't even have an equitable interest in it and shouldn't have. Now, you mom and pop landlords out there, even if you're registered, in your quote unquote state capital, check in with me, because I think you have some affirmative defenses here that they do not have. So interesting subject, but you've been fraudulently induced into the system just like we have. But these corporations and all the expensive corporate attorneys are going to Starboard, Vail, UC, Berkeley, Stanford, all of them knew or should have known, and their ancestors were much more likely than not to have been involved in all this crap that went down from the 1860s on forward, if not earlier than that. Video for another day. But they knew they've been the main beneficiaries, and there's a maxim of law that says he who accepts the benefit must bear the burden. Ain't. See you later. Can't come into our judicial courts, can't compel us into yours. How good is that? Exactly what I think the framers had in mind with the original intent of the Constitution. Wow, it's just so good, and it's the way it's supposed to be. And instinctively, when you hear this, it probably is going to register, and we're going to make it register if we have to with the jury, because we're going to educate them. Because among other things, and this is true across the board, by the way, with people with mortgages and things like that, and student loans, that I'll be willing to make an appearance as an expert witness at a contested hearing, or better yet, a trial by jury, probably by Zoom, although I would love to make a personal appearance in the jury trial if it's at all possible, because you give me about 15 minutes there, and I could go for a hell of a lot longer than that. But I'll begin to educate the jurors to what the law really is and let them know they have the power to rule on the facts and the law. That's one reason I never got close to a jury in my South Carolina felony case 5 years ago. Well, I can't believe I'm saying that part. But I shut him up the first 30 seconds of my initial appearance. That's $1 million video if I had it stunned the courtroom into silence. And the charge there, by the way, practicing law without a license. And I'm the one standing there shackled hand and foot in a red jail suit. I laughed. And I said, the problem with that is I don't practice it. I get it right the first time. And I still do, for what that made me worth. And then they said, well, the judge, who I think was one of the good ones, said, well, we have to check and be sure you're competent to represent yourself. If I could have thrown up my hands, I would have. And I laughed and I said, oh, barf better. Beretta v. California, Judge 422 U.S. 806. The problem with that is that the U.S. Supreme Court decided in Barron v. Baltimore, 7 Peters, U.S. 243, 1832, the Bill of Rights doesn't apply to the states. Stunned the courtroom into silence. That feeling, I mean, I'm right, they're wrong. They're the ones in trouble with the law, and everyone knew it. I can't tell you how good that feeling is. And that's one of the things I hope you get from the car in my modestly priced constitutional defense document packets, which are, by the way, valid across the board, not just limited here, to the mortgages and student loans and what have you, and eviction things. It's across the board, criminal, IRS, I mean, you name it. Any government agency in the government in which we are not represented and can't even register to vote. And to do that, by the way, certainly in California, I think in every jurisdiction in the country, you have to declare under penalty of perjury that you owe your what I call birthright citizenship to Section 1 of the non-existent 14th War Amendment. And this is the government they think has control over we, the people who ordained and established this Constitution? I don't think so. And hopefully the 9-0 farts are no longer thinking so after what occurred in the last term. We'll wait and see what develops in this term. We just opened a week or so ago. I'm looking forward to it anxiously, especially, by the way, with quote unquote, the abortion issue. I'll be doing an upcoming video on that one. And those of you that are keen on that, forget about Roe v. Wade. Hasn't been valid really since day one. It's been treated that way, but Hip Pocket Harry Blackman, wrote what was known in the court at the time as Harry's abortion, didn't even clearly identify a provision of the Constitution on which it was based. It's sure as hell not the due process and equal protection clauses of the non-existent 14th War Amendment. That's a video for another day. Meanwhile, in the instant case there, with the landlord tenant situation, contact me for information and I'll get it out to you. Send me an email, uwinnincourt@gmail.com. You're going to love what goes on here, even in their corrupt courts. And like it's true with all of the other situations I deal with, this one, risk versus gain. If you're a quote unquote landlord, especially a corporate landlord, you do not want any of these issues to come out on the record. And especially if any one of them gets decided against you, because just like with mortgages, that nullifies every lease from Portland, Maine to Portland, Oregon. Risk versus gain. That's the power we have over these bastards. Oh, sorry, I get excited a little bit. I know I do, but it's just all the work I've done and what I know and what I can teach you. That's even more important. And you can teach your children and your posterity so they don't get into situations like this anymore. That's even better. And that's why we're going to resonate in front of a jury, because we get in there, especially if we set an unopposed record, and end up beating them with that. Now the situation is that they won't even go to trial because they can't have that come out on the record and can't have people like me as expert witnesses educating the jury to know exactly what's going on. So that said, remember to subscribe, like the videos, tell your friends, get the word out. As soon as we cut out all this divide and conquer crap they've been doing for 150 years, if not more, and work together, same issues, same standing, same court, the quicker we get these corporate bastards off our back.